This is Musings and Counsel from London Baker Law with Debbie London Baker.
Explain to people what is estate planning.
Estate planning is looking into your world and knowing that you have assets, whatever those are, or bounty, as the legal term is. A will is about what is a person signing a last will and testament, knowing that it declares what they want to do with their bounty. Now, that word's not in the will, but that's the legal jargon, as I remember. It's not mutiny on the bounty. It's bounty, like whatever. So if I looked around my office, it's all stuff in my office. That's tangible personal property. That's a different way. But an estate plan will allow you to lay out what you want done with all the money you might have, whatever that looks like. If it's coins I save nickels, dimes, pennies, and quarters. Who knows why, but I do. I don't know that I have thousands of dollars, but I have hundreds of dollars, and I hate to wrap them up because then I have to start filling the bottle again. So anyway, but that's part of your bounty. Well, you might say, you might have a piggy bank that you've had since a child. My husband had one that unfortunately got stolen. But you might have a piggy bank you've had since a child, and you want that to go to a specific person. It's full. You have no idea how much is in it, but you want that piggy bank with whatever's in it to go to a certain person. Well, you would want to write that down. Or you have CDs that matured and you never cash them in, but you want to be sure you've designated who they go to. That's beneficiary designation. So that's part of an estate plan, because if you write down you want them to go to Sophia, let's say, and you haven't put her on that piece of paper and you're not married, she doesn't have a legal right to that money.
Whoa.
Your family has a legal right to that money. Your blood family, whether it's children or parents or nieces and nephews. So Sophia, whom you've been with for a long time, as much as you may think, of course it's hers, because we've been together all these years. That's good thinking, logic. But if you go to a court of law, unless you've written it down somewhere, even in your will, that says Sophia gets all my money markets or CDs, she doesn't have a leg to stand on if people in your blood family say, sorry, we never liked you. We don't care how much Steve has. We're going to argue. We're going to fight you for it. So estate planning is putting that all, you said at the very beginning, it's the most important part of law, whatever. Just what I do is what estate planners do. It's helping people pull together what they have in one place in their mind and putting it down on paper. So people who are going to take care of them in this life or take care of what they have after they're gone, do what you say you want. And there's extraordinary peace of mind in getting it done. And I know I keep coming up with things. I'm going to have my colleague and mentor review my estate plan, because I did it years ago, and I did it with somebody I didn't know. We just decided to do it. It was finally time, and I'm thinking, holy mackerel, Debbie, you need to be sure that you've got everything in place. So that's what estate planning is. It's just, it doesn't matter how much money you have. It doesn't matter.
Debbie, who needs to have an estate plan?
Well, people really struggle at hearing this. At 1 second after midnight on an 18th birthday, whoever that 18-year-old is needs an estate plan. And people say, that's crazy. They're only 18, or they don't have anything. Right? I get it. I learned about that years ago when I was a sort of semi-active associate with one of the prepaid legal programs, when somebody told the story of an 18-year-old who had a catastrophic injury in a car accident, didn't have a will. Why would an 18-year-old have a will? He was raised by his mom. His father had nothing absolutely to do with him. And because he didn't have a will, when the wrongful death or personal injury thing settled, his father got 50% of that money because there was no will. So that's the tragic piece of it. Camp Lejeune cases, the people who are families or victims of the Camp Lejeune, they need to do, if there's no will, or they need to do a probate so they can be in line for their family descendants, the spouse and family of the people who died as a result of that, to collect a class action settlement. But the biggest thing that people, 18-year-olds struggle with that, which is understandable. And parents don't understand that they cannot call a doctor anymore once that child turns 18. They can't call a teacher anymore once that child's 18. They can't access bank accounts if that child has one in their own name once that child is 18. They have no legal rights other than they don't even have a legal demand to support them anymore, but they have no legal rights to help them without the child saying so. And then any asset. I mean, you mentioned recently, Steve, that you did your first plan when you were 27 or 28 because your brother is an attorney and said, you will do this. And you said, okay. But I don't remember you saying you had a lot of assets that you owned a fancy car or owned a home or anything. You may have, but you weren't married. And as I remember, you didn't have a family. So why would you do it? Except that he was smart enough to say, you're 27 years old. And if God forbid something happens to you, you need to put me in charge. You need to let somebody know what you want. So once you're 18, you need one, whoever it is. And 18 is the legal age of adulthood, I think, in every state. It may not be the drinking age, but it's the legal age of adulthood. And that's the determining factor. So that's who needs it, everybody over 18.
This has been Musings and Counsel from London Baker Law. Learn more at londonbakerlaw.com. Thanks for listening.